Companies Act, Section 278, Legal Effect and Scope of a Winding Up Order. Section 278 of the Companies Act, 2013 outlines the legal consequence of a winding up order issued by the tribunal. It establishes the principle that once such an order is made, it is presumed to benefit all creditors and contributors of the company regardless of who originally filed the petition. This provision ensures equal treatment, fairness, and collective recognition of rights in the winding up process, thereby removing any distinction based on who initiated the proceedings. Substantive provision, legal fiction for equal benefit. According to Section 278, the order for the winding up of a company shall operate in favor of all the creditors and all contributors of the company as if it had been made out on the joint petition of creditors and contributors. This single-sentence provision carries significant implications for the conduct and legal interpretation of winding up proceedings. Key components explained. 1. Universal effect of the winding up order. The moment the tribunal passes an order for winding up a company under Section 273, that order is deemed to benefit everyone who has a financial stake in the company's affairs, namely creditors, who are owed money by the company, whether secured or unsecured, and contributors, who are current or former members, typically shareholders, of the company and may be liable to contribute to the assets of the company during winding up, particularly if the company has unpaid share capital. The law treats the order as though both groups had jointly filed the petition, even if the actual petition was presented by only one party or a third party such as the registrar. 2. Fiction of joint petition. By creating a legal fiction that the winding up order was made on a joint petition, the section ensures no party is prejudiced due to not having filed the petition themselves. All relevant stakeholders automatically become part of the winding up process and are eligible to participate in proceedings such as filing claims, attending creditor meetings, being consulted by the company liquidator, receiving a proportionate share of the liquidation proceeds, in accordance with priority rules. Implications and rationale. 1. Promotes equality and inclusion. This section embodies the principle of fairness, ensuring that all affected parties receive equal legal standing once the winding up process begins. The financial distress or insolvency of a company impacts both creditors and shareholders, and this provision reflects that reality. 2. Reduces procedural complexities. If each affected party had to independently file a petition or be formally joined to the proceedings, it would lead to unnecessary delay, duplication, and administrative burden. Section 278 simplifies this by granting automatic inclusion and benefit. 3. Supports efficient liquidation. Allowing all stakeholders to benefit from the order encourages faster identification and settlement of claims, better cooperation between stakeholders, and smoother implementation of the winding up process by the company liquidator and the tribunal. For more details, contact us.